Going to start now. This is our 154th Friday group meeting. The speaker is our beloved Dr. Karnika Seth. Earlier also she addressed our Friday group. That is 51st Friday group meeting. The topic is cyber crimes and electronic evidence. That is on 28th April 2017. The second time, that is 114th Friday group meeting. The topic was changing laws of data protection and privacy in India. That is on 13th May 2019. Today's topic is New Intermediaries Guidelines 2021 and Intermediary Liability in cyberspace. Thank you very much, Karnika ji.
My pleasure.
I request Rahul will give a small CV of you just for after this thing.
Dr. Karnika Seth is an internationally renowned cyber lawyer, an aggregated international arbitrator, accomplished author, policymaker, and a highly inspiring speaker in tech think tanks, conferences, media, and television. An eminent cyber lawyer and advocate in practice for over 2 decades, she actively handles cyber crime matters and cyber law-related litigation. She is the founder of Seth Associates, an established law firm in India that advises global companies on information technology and media laws, IPR, besides other areas. She has been appointed as a legal advisor to the Ministry of Information Technology, Government of India, and advises the government on various international and national initiatives to strengthen India's cyber law regime. She has actively contributed to the work of the E-Committee of the Supreme Court of India on making our e-filing process in courts across India robust and efficient. On the UN International Women's Day, she received the Great Indian Woman Award in 2021 and the India Beyond 75 Platinum Excellent Amrit Award 2022 for excellence in the new and future tech laws. She graduated in law from Delhi University and attained Masters in Law from King's College, University of London, doctorate degree in Cyber Law, PhD from NIU. He specialized in computer security from Harvard University and is the member of the Chartered Institute of Arbitrators in London. She is also an impellent arbitrator with World Intellectual Property Organization, Geneva, and the National Internet Exchange of India.
1 second. Finish with this book was published by Karnika Seth recently 2022. Excellent book. Computers, Internet, and new technology laws. Thank you. Just
Thank you so much.
proceed. It's okay?
Am I audible?
Yeah.
It's indeed a matter of great pleasure for me to be here again with the Friday group. And today we are going to be talking about intermediary liability. Intermediary liability is a very important area of cyberspace. And as we all understand, the implications are far too many. And that is the relevance and importance of today's talk on intermediary liability. We will be covering various aspects throughout this talk. Who is an intermediary as per the law. We'll also be looking at the various kinds of provisions which are there relevant to this topic in the IT Act. And we look at various dimensions of this liability regime, particularly when we talk about direct liability, the contributory liability, and the vicarious liability aspect. So we will start by a couple of these provisions, and then we'll obviously be talking about the case laws connected with the same. Initially, I just want to start with Section 2(1)(w) of our IT Act. As we all understand, IT Act is a special law in the country which governs the internet and cyberspace and all electronic transactions there. The Section 2(1)(w) in particular talks about, or rather provides the definition of who is an intermediary. Now, as per the Act, intermediary is defined as any particular with regard to electronic records, means any person who on behalf of another person receives, stores, or transmits the record or provides any service which with respect to that record and includes any telecom service provider. For example, you have an email service provider, or these days we have online shopping malls. We also have various service providers like internet auction sites, online auction sites. and cyber cafes. And you will see online payment sites which facilitate payment transactions for various, I would say e-commerce, which is happening online. So all these are basically an intermediary as per the definition of the intermediary, in the IT Act. Now coming to the other provision, which is very important for our discussion, is 79 of the IT Act. Now section 79, if we see that section in particular, it is basically giving exclusions or exemptions from liability. Now coming to section 79, when is an intermediary not liable? It is actually of the nature where it can take as a defense. So in a case where the accusation or the averment or allegation of a party, for example a plaintiff, is that the platform, for example if it's a social media platform or if it's an e-commerce or a shopping mall, there is a liability, plaintiff alleges there is a liability on their part which is contributory or direct, for instance copyright infringement or trademark infringement, or it could be any other fact scenario. There the defense can be taken by an intermediary that if it's, for example, an online shopping space, it is not the seller, he is not the seller, or the platform is not the seller, but is only providing a means, a space where the buyer and seller meet and exchange the information, or goods and purchase of services takes place. Now in such a scenario, there is a condition given under section 79 that in such cases that exemption is only available subject to the fact that this intermediary is neither initiating the transmission, that is neither selecting who the buyer or seller will be, what is the content which is exchanged between the two, that is not determined, plus it's not modifying the content either. So neither deciding the receiver of the transmission. So that is a key feature that one has to satisfy. Apart from that, there is also an intermediary is not liable for any third party data. Third party meaning, for example, on a social media site somebody is posting as a user, so that is third party content. They are also not liable for that content which is being put up, even if it's infringing, because such a platform, like maybe if you look at social media platforms today, big giants, Facebook or other platforms, they cannot monitor everyday basis the millions of pages and posts being put. So from that perspective, this was so that there is no chilling effect on the freedom of speech, and freedom is not curtailed. That this provision helps to that in that extent that such platforms can easily and freely transact business. However, they will be subject to liability when they are conspiring or they are aware of the infringing actions and facilitating it. That is where the contributory liability will come into play. And also they could be vicariously held liable where they have not taken due diligence measures. That is another aspect to it, that you may not have the knowledge, actual knowledge, but you have not basically looked at the due diligence aspect. In that regard, then if you have not complied with the same, then this exemption is not available. So there are certain criteria laid down. The intermediary has to observe due diligence guidelines which are given by the government, and we are going to talk about the new and the old guidelines of 2021 and 2011. 2011 guidelines of due diligence of intermediaries have been superseded by the new rules which are of 2021. Now, as I said, if there is a conspiracy of the platform with the seller, for example, it knows that there are fake goods being sold on that platform, certainly that platform will be liable if there are facts and evidence can be led to prove that there was a contributory factor or there was a conspiracy happening in those scenarios. And upon actual knowledge, supposingly there is a particular obscene content, for example, on a particular platform, that has to be removed. So the notice has to be sent, and the police, for example, conducts investigation and says that you need to take this down. So that taking down has to happen within 36 hours. In case of sexually explicit content, the new guidelines say that you have to do it in 24 hours. So that is the stringent law which we have in the country today. And if they fail to remove this content or take it down, then there are definitely repercussions. The legal remedies come into play, and the liability can be invoked under any law which is applicable, even IPC and IT Act. So that is the current position of section 79. I'll come to the intricacies of the same with citing some examples of what we have seen in terms of case law in the country. And before I go to that, there's another material section which I want to point out, which is 85, which is for deemed liability of directors. Now, in such a case, in deemed liability, every officer who was in charge of effective monitoring of the organization and responsible for the computer system or resource, if is being negligent or has the knowledge and yet he has not taken due measures to correct that, take down that particular infringing material on actual notice or otherwise, can be held liable, because that is a provision of deemed liability. That is, they have to prove that they conducted their business with due diligence and there was effective monitoring happening and they had no knowledge of such illegal activity happening within their organization or through the use of those network and resources there. So that is section 85. How different is it from the earlier section? This was the 2011, there were the earlier rules, and even section 79 prior to 2009, that is 27th of October 2009, was a different section altogether. Now, in that particular section, the provision said that network service providers will have to prove, in order to escape liability, that they had neither, they had exercised due diligence and they had no knowledge of this offense being committed in their company. They had to prove it. Now, in that particular section 79, it was only pertaining to the purview within the IT Act. Now there's a non-obstantive clause which has been added in the section 79, which means that even if an intermediary, he can claim exemption, even if other laws, actually if you invoke the other laws, he could be held liable under those laws. But if he has able to satisfy the due diligence and other parameters of section 79, he can actually claim the exemption from liability, not only within the confines of the IT Act, but for any other law, because this is a special law. So that is, the power of this section 79 now, and it's been expanded in terms of scope, even with regards to the kind of intermediaries which can be clubbed under this particular provision. Okay, so coming to the aspect of new rules. Now, under our old rules of 2011, there was this condition that you have to, satisfy. There has to be a privacy policy, a terms of use by every website owner. Now, these conditions, and then they have to apprise the user that they cannot upload such content which is, unlawful, which is defamatory, or which is something which is objectionable, like obscene or otherwise. There are also certain there were also other provisions like having a grievance redressal officer in their organization which redresses the complaints. Now, similar to that is now the current law, but the the current 2021 rules have made the problems, these considering the kind of implementation problems which are occurring. The speed of implementation is slow, so in order to enforce the laws better, they have made the provisions more stringent. Having said that, things like spoofing, hiding one's identity, using VPNs or otherwise, sending messages, even fake news, they all can be covered under the new rules. So they are asked not to send certain messages like these, or impersonation, messages which threaten the sovereignty or integrity of India. And there is a power to block with the website. The website can actually block and terminate such accounts which are using phishing or other kind of techniques to commit crimes. So that is there, and we see that all the time. There is a lot of positive implementation of the same, because like in the payment apps scenario, the banking ombudsman in the banking system, they are effectively resolving complaints. Similarly, grievance redressal officers, they are supposed to be now resident in India. That's a very good measure, because earlier there was just an automatic message being sent which was not leading anywhere. But now they are supposed to, within a timeline of 24 hours in obscene cases and obscene material cases, and otherwise within 36 hours, they have to get these problems resolved, and within 15 days is a timeline given for complete resolution of the complaint, and 72 hours to get back and even cooperate with the law enforcement agencies. So that is a quick remedy which has been given, and solves many cases initially. Then coming to the point that whatever data they collect, they are supposed to collect it for 180 days. They have to keep that data. If there's a complaint case, the logs have to be maintained, IP address has to be maintained. Now, social media giants say we have encryption, we don't monitor content, but they are supposed to identify the originator. Who is the first originator? And because these videos, these messages, fake news goes viral, so how do you curb that? That is why the government has introduced these new rules, that at least you let us know who is the originator. So the IP can be tracked and the cases can be resolved based on that. So that's another good measure. And they have to obviously maintain privacy and other practices as per the IT Act. They are supposed to do that. Now, reporting of cybercrime incidents is on the cybercrime.gov.in portal, and thousands, and I think recently there was a meeting at the MHA also, we were discussing the same, and there are thousands of cases which have been reported in a year, more than 25,000. So you can imagine the pace at which cybercrime is increasing. Every second there's a crime, and these rules are becoming more and more relevant and more important from that point of view, to curb cybercrime and to get a legal redressal of the same. So now, another important aspect of these new rules is that they have identified these big giants, social media giants, as a significant social intermediary. Now, as per that, if they have a user base of 5 million or more, then they actually have more due diligence norms to be followed. So they have to have a chief compliance officer, they have to have a nodal contact, then a grievance officer, and the data security measures are also higher. They are supposed to comply with various reports and tech tools to identify what information is being put on their platforms. They can have, like in Facebook and otherwise, you can have a tick sign, verified account. They can voluntarily apply for a verification of their account. And the softwares which they are developing should be not I would say violating data ethics, data science. We have AI, we have metaverse, we have, we're talking about crypto today. Whatever softwares you're making they should be free of bias and discrimination. So that kind of ethics has also been reflected in the new rules. So the significant social media intermediaries, while they're devising these AI platforms, they will have to be mindful of these data ethic norms as well. And then apart from that, if you see, there is a acknowledgement that they have to give when they receive a complaint, and act within the timeline, that is 36 hours. And they also cannot say that we don't have knowledge. I'm coming to the main issue of the kinds of involvement a platform can have in terms of engagement. It can be simply a conduit like a telephone company or an email provider. It can have more involvement like an online shopping mall. When we buy goods from a particular shopping mall, sometimes the bill is raised in their name, warranties are given, they guarantee that the particular goods are going to be genuine, And they also have delivery boys. They have delivery logistic support. So can we say they are just an intermediary? These are questions of evidence. They will involve evidence. They are questions of fact. And in a lot of cases, you would have seen the Amazon case also, the judgment, where very elaborately this has been explained, that who is an intermediary, and these questions require a proper trial. So you cannot immediately on a prima facie basis in an interim order say this is an intermediary or not an intermediary. So that's the interesting part of these kind of cases. And when it comes to the liability aspect of such intermediaries, there have been many cases. There are a plethora of cases by now, but I'll take you through the journey. I wanted to discuss the provisions and some basics of the aspects involved while we're discussing these scenarios and what are the key legal concepts. But now talking about cases, the earliest I can recall is Bazi.com case, the first case where we actually extensively dealt with this. And there it was if you recall, the DPS MMS clip involved, and that was uploaded by somebody on an auction site. The CEO of that auction site, on Bazi.com, Avnish Bajaj, was arrested, and there was a prosecution which followed, 292 and Section 67 of the IT Act. Publishing of, transmission of any kind of obscene material. Right? Now, if that were the provisions, in this case, it was finally observed in facts that despite actual notice, the platform had failed to remove this obscene material. Obviously, there was a liability attached to that, and deemed liability of directors was the provision considered there, Section 85. And it was said that quashing can happen under IPC or 67. It was said deemed liability provisions are there, so it can't be. But later on, in Anita Hada case, the same case was looked into, and then it was held that where the company has not been arraigned as an accused, the director cannot be made vicariously liable. That was the final decision on that factual scenario. So obviously the FIR got quashed. So now coming to what happened later on, I had the occasion to argue one of the very interesting cases, Nirmal Jit Singh Nirula versus Hub Pages, before Delhi High Court. Now there the question was defamatory material against the plaintiff, and that defamatory material was not posted in India but from abroad. It was on Hub Pages platform, which was a US based site, and they were hosting it also abroad. Now the question was, does India have the jurisdiction? The Indian courts has the jurisdiction. Now defamation was taking place here, party was affected here, and if we see Section 1 of our IT Act read with Section 75, we have a prescriptive jurisdiction. We have jurisdiction which is beyond Indian borders if it affects any computer system or resource in India. So the person was defamed here, so we filed that action, and the Delhi courts said that they have the jurisdiction based on the banyan tree case. And there has been interactive, I would say, injury was there, and the site was interactive. It had user base in India as well. So the registrar of the website was asked to take down the material, and this was the registrar cooperated, and the party, that is the main defendant, the website itself, actually removed it voluntarily without submitting to jurisdiction of Delhi courts. So this was a case scenario, very interesting, one of the earliest cases of 2011 rules of Section 79. Thereafter, there have been many other decisions. Shreya Singhal is one of the key decisions we all know about. Shreya Singhal's case, a very important aspect of this Section 79 was clarified, that 66A was struck down because it was unconstitutional. The words used are offensive material, and they were very ambiguous. What is harmful, or objectionable is something that can be subjective. So prone to misuse, and that was the reason why it was struck down. But one material aspect of that Shreya Singhal case was that actual knowledge aspect was clarified. That if there has to be a blocking vis-a-vis freedom of speech, 19(1)(a) of the Constitution, Article 19(1)(a), if there has to be a blocking, it has to be only when there is a court order or order by an appropriate government agency of the government. That was clarified, and that would be only in 69A, section 69A invoked cases where there is a threat to national sovereignty, integrity, and public order, decency, morality. Defamation would not come under that thing, right? So that is what the import of that section and that particular judgment was, and very relevant, very important judgment. Then we had very interesting cases of copyright and trademark, where especially in the MySpace case, if you see MySpace versus Super Cassette Industries, this case was a case where it was held that the scenario over there in Shreya Singhal was freedom of speech involved. We are talking about copyright in this case. And the court really held that there is a difference. There is a difference because we are not talking about freedom of speech, you're talking about freedom of trade. Copyright is something that one can, if a platform is informed that on your platform there is a copyright violation and given proof the same, they are supposed to remove that content within 36 hours of actual knowledge of the notice. So in copyright and trademark cases, at least those this principle should be followed. Now there was also another aspect, that where there is a connivance, in such cases, obviously if you're abetting a fraud, abetting an infringement, then you're a contributor. You can't say that I have exemption because I am excluded, I am an intermediary. That plea doesn't work there. So we have to very carefully, in every fact, case which comes to our for our review, we have to look at the factual scenario, what is happening in that platform, to analyze whether first point that this is an intermediary or not, and if it is not an intermediary, then it's a different question altogether. But if it's an intermediary, can we claim this exclusion? Are we satisfying due diligence norms? Are we also, can we say that we did not have knowledge, which is not deemed or constructive? We're talking about actual knowledge. And then we have also to look at, if you're following everything, we have conducted due diligence, we had neither knowledge nor ability to control content. Did we give them a software which actually abetted the infringement? Those are the aspects, very interesting aspects, which these cases have really brought out before us. And certain cases, it was also examined where the platform itself, showed that there was this was a shop clues case, if you recall that, where there were fake products being sold. It was alleged that there were fake products being sold, and there was a website where it said replica window. So if a website is showing replica window, means they are aware of the infringements which are happening. So that's what the court observed in such a scenario. They cannot say that they were not aware of infringement, therefore they would be sometimes even a court could hold that there would be a direct infringement by the party, by the platform, or they could hold in the circumstances that this is a contributory infringement. Now in Super Cassette Industries, the question was this: if there were videos or clips or small trailers which are uploaded on say MySpace platform, and this MySpace platform said that we were not aware of any such infringements by people who have posted it, but they were they had the ability to control content because they were actually editing and placing ads on the content. They were able to modify the content also to that extent. So if you have the ability, you've reserved the right to monitor, and you also abetting it in some way, giving your platform as place for profit, that could be at least a contributory liability, if not a direct liability. So those are very interesting questions which are being examined in these kind of cases. And interestingly, in cases abroad, if you see, there have been Netcom case, the Napster case, and Grokster, where P2P file sharing, portals were into picture. And then again the same principles were examined, whether the platform was abetting the infringement or not, whether it was directly involved or was it only facilitator or abetment. But in our section 79, it says very clearly, even if it's an abetment, it doesn't give you the right to claim exemption anymore. So that's the principle which we all follow. Then there have been other cases similar to Netcom. You have the Sega Mafia case, and then there have been lately X versus Union of India. You would have heard about this case as well. I'm sure we are all using these precedents and interesting developments. So if any obscene content is being floated, on a particular platform, and police informs that you have to remove this after a complaint is lodged. So on actual notice, if they don't remove it, then the platform is liable. So in such a scenario, within 24 hours, they are supposed to take down the content. That is been held, and there are global blocking possible, takedowns possible. Now, in such a case, there have been decisions which say that it cannot be only limited to India, takedown only in India. There can be global takedowns. Those cases are also interesting. I've seen that in the Swami Ramdev case, if you would have gone through it, versus Facebook. Swami Ramdev versus Facebook. The defamatory content was there. It was directed to be taken down because there was defamation happening, and it was held in that case that this cannot only be limited to geo-blocking, like within India, takedowns, but it has to be global. Because if a platform has the ability to take down content on voluntary basis, then why not obey the court order? Which makes sense, logical sense. They have the technical capability, then they should be able to do it in such a scenario. If they are doing business here, they are supposed to obey the orders of the court, otherwise it will be contempt. So that's what has been examined in those cases. Then I was also going through the Amazon case, which is very interesting. I've already discussed a bit of it, but the Amazon case helps clarify this area to a great extent, that this is more of not an affirmative enforcement provision, section 79, where a plaintiff can say I'm an intermediary. It is more of a defense. So that aspect has been very clearly brought out in that Amazon case. Then we had Google versus Vishakha. Again, an interesting case on point, where again there was defamatory material put, and it was held that there is no escape from criminal liability in such a case also. If there's a defamation material, and this now non-obstante clause has been added, but before that this case pertained to facts where there was an old provision, where there was no exclusion from other laws, exemption from operation for other laws. So under IPC, they said the IPC can still apply, and there would be no exemption from criminal liability on that account. So the section 79, the old section 79, it was clarified that vis-a-vis 499 and 500 of IPC, that criminal liability can still be claimed. That can be. So likewise, there have been many other important decisions, but I want to just throw light on this fact that when it comes to liability of intermediaries, the long and short of it will be that one examines what is the nature of activity and the rights and control and the policy of that particular platform. If the rights reserve their ability to look at the content and maybe even decide the receiver, sender of a particular service or content therein. For example, there are blogs today. There are various other features, like they are looking at the content and putting an ad on it, or they are providing other services. So in the section 79, there is no difference in active passive websites or active passive intermediary. That was also been discussed in all these cases. So what is very clearly put out is the key criteria will be the due diligence aspect has been met with by the platform or not, whether there is a conspiracy or not, abatement or not? Are they gaining direct profits from that, having that particular platform? Or is it only a conduit, providing that space and not aware of the infringement which is happening? Do they get an actual notice from the customer that this is happening and they remove this or not? Those are factors which we have to see. And in especially copyright trademark cases, they are supposed to take down if there is a violation. In cases of obscene content, they are supposed to take down if they can apparently see this is prima facie or obscene content, within 24 hours take down. But in cases where e-commerce, like I said, online shopping malls, it requires an extensive trial actually to look into that fact and actually say whether this is an intermediary or not. And therefore it is important to see whether the platform was abetting or not, or indirectly involved, looking at all these facts, and then one has to decide whether there was an intermediary or not. And if it was, then can it satisfy all the conditions before it can claim exemption? So if that is there, then that argument will flow in that direction. So having said that, I think we are still work in progress in terms of intermediary liability. India, if you look at India, we have new technological developments happening every day. How AI will play a role, or how metaverse, virtual reality, or other kinds of violence happening on online space, gaming, fake news, all these are new things which we are still making laws on, and we are still looking at various aspects of these new emerging future laws. What will they be? And from that point of view, how, if intermediaries are using these technologies, will be impacted? Will there be a more stringent criteria for having such technical tools? Because we already see in the 2021 guidelines the use of data ethics and data science is reflecting. Similarly, for the new, maybe we'll have to pace fast and have a new set of laws which will deal with these issues, and very clearly examine them in light of whether still an intermediary can say that he has complied with all the due diligence norms of metaverse, of AI, or of combating fake news. Have they deployed the technological tools required? Have they put the data safety and data protection mechanisms in place? And can they say that we did not have knowledge of this infringement, or we did not have actual knowledge? So the concept of vicarious liability will have to be examined, the concept of direct liability will have to be examined, and then contributory liability will have to be examined. But from the international scenario, if we see the international scenario, they mainly see in the Netcom case also, they saw whether there was an ability to block or ability to control content, and reserved the powers to do that in the policies. But in India, we have an extra criteria of actual knowledge. So we've actually added a new pillar to it, and we say that we have given them more immunity, I would say, more freedom to work, as long as they are compliant with our due diligence norms, as long as they are not deciding who the receiver will be or who the initiator is, what is the content, and as long as they are not abetting or conspiring with the sellers or otherwise, the third party, they can claim the exemption given under the section 79 of the IT Act. Now with this, I just want to take up a few questions from you all, and then we'll delve more into this while we are talking about it. Would you like to have?
Yeah, I just want to know, India stopped so many websites because from China.
Yes.
And is all the website has got a face or a corporate office like things where you are knowing that against whom you want to take action? What is the mechanism that can we control the website's movement or the apps in India? Is it there's a mechanism, or the law knows it, how to handle it?
Yes. It's an important question. We all, when we deal with making laws or when we deal with law enforcement in these cases, we normally see that there is an IP address linked to every system. Now, I know the criminals are one step ahead, so they will use VPNs, they will use proxy servers, various sites, but now we have new set of laws. Every second day we have something new happening, so there has to be new laws for the same. So even the Ministry of IT has come up with incident response. So if a fraud happens, supposingly there's hacking, so within 6 hours of that fraud, the new guidelines say that the company needs to report the same to the computer emergency response team for immediate action. That compliance is there, and they will have to cooperate with the law enforcement teams to find out from where this is happening. There is also log retention requirement, so they are supposed to keep logs, and this 180 days again they have to maintain the logs for, and they will have to give the logs for investigation purposes. So all these payment sites, all the e-wallet companies, even non-financial companies, e-commerce platforms or otherwise, they are supposed to keep these logs and cooperate with the law enforcement. Yes, there are criminals who are using Tor, who are using anonymous proxy servers and other servers. Therefore, for such cases, there is a cooperation needed. And for financial data, there's a strict now guideline that they have to save that mirror image copy of that in India. The data has to be in India. In fact, the RBI is keen to have the data entirely saved in India, which pertains to financial transactions of Indian users. So the other data can be non-sensitive data, which is not payment related, can be in a server abroad, but available for investigation reasons or identification reasons on incident response, as a part of the incident response when it is reported. So there are new set of laws we have to come up with, and there are still some grey areas which we are trying to curtail. But to whatever extent possible, the tracking is happening and cooperation is being sought. The only area which I immediately recall is this the Convention on Cybercrime. We have not yet signed a convention. India has still not signed. So for cross-border crime, Interpol is there, we have MLAT system, letter regulatory system, which is very slow. So that is an area which one really needs to work on as well.
Rahul,
There's a question I just want to ask. We are talking about the intermediary liabilities. Supposing there is a website in which some obscene concern is being uploaded by anyone, so they are taking the defense that we are not aware of it. So would not the government should it mandatory that while building the website, they should, with the help of the AI, they should keep it like that, like they have, what every video has been uploaded, it should be go through the AI. If the AI found out that this is some obscene content, they should not upload it.
Yes,
So
I agree. To that extent, these norms are being very strictly followed in child pornography cases.
Yeah, absolutely.
We see platforms use DNA photo hash mechanism, and there are various other means by which keyword filtering is happening, and they are removing this content. Likewise, duplication of such content, especially if it is the same content being made viral. We've had the concept of dynamic injunctions of late. We will all be aware of those Ashok Kumar orders, or the John Doe orders we call them. So in those cases, and even in most of these decisions, whether it comes to dynamic injunctions, they give a ban on duplication of this content, so that it can be immediately blocked. Time and again, the litigant doesn't have to come and approach the court every time there's a new link which is circulated. So that is the I would say advantage, extreme advantage, I would say great advantage of having these dynamic injunction orders, and that is serving the justice, ends of justice in this case.
No, what I mean to say, the website is in our control. Supposing I build a website,
Yeah.
that is in my control completely. I am giving some privilege to someone to upload some data over it.
Yes.
That's a different thing. But that should be on my perusal.
Absolutely.
I should be saying if it is okay, then it should be on the website. Otherwise, I'll.
So you are talking about pre-censoring.
Pre-censoring.
Pre-censoring, especially in those cases where it is your own website, you can choose to do that out of due diligence measures. But in cases of, as an intermediary, if you're talking, then for social media, related or other intermediary cases, that pre-filtering or pre-censorship is only right now enforceable to that extent of child pornography or other cases. It is not something, it's more out of self-regulation than a government requirement.
Yeah, yeah.
But that self-regulation has now merged with certain industry norms now, because I would say it is expected. Now it's part of the guidelines also. The new rules of 2021, for instance, have a stricter guideline to remove obscene content out. Earlier this was not there. 36 hours was 36 hours. Now why we have 24 hours for this kind of content? Because we are trying to enforce our laws better. We are trying to make a more stringent law to that effect. Maybe it is 24 hours will further reduce to 6 hours, like we have in cyber incident response cases. So likewise, we are seeing a growth in terms of evolution of law, and depending on the demands of the situation. So maybe the next step will be pre-filtering as a mandatory requirement.
Absolutely.
But the social media platforms are not, they say this is not technically feasible because it will stifle the freedom of trade and freedom of speech, because we can't possibly monitor so many millions of pages every day. That's the usual stand that they have actually taken in such scenario, and keeping that difficulty in mind, these provisions have been, Section 79 has been enacted. So for it to change, we will have to change the Section 79 also to that effect.
You want to ask any question, madam? Please, Sam.
Actually, sir,
Yeah,
few
please.
minutes back I joined, sir.
Yeah, it's all right. You want to ask some law? Just you also join. Rahul, you want? Yeah, please. Yeah,
Yes,
please.
please.
One example like that, it's banks and some that you don't click it. Is there any mechanism to stop that, and the agencies giving an ad if they spend on the investigation to stop that frauds, and people booked in the behind the bars are the correct legal aid, so it can be act as a threat. Your view about it? Because sometimes they we alert that SMS is even
Yes.
recently SBI and in full-fledged ads are coming in, but there is no kind of an information that banks or the government agencies have taken steps to the fraudulent
Okay.
and
Fine.
brought to the books of the
Yeah.
justice.
So, the Reserve Bank of India has passed various guidelines on that effect, and there are also, the Ministry of Home Affairs also has this helpline is there, 1930, and cyber frauds are being reported on national, cybercrime.gov.in portal. And as per the statistics of NCRB also, it has the cybercrime incidents have risen to a great extent in India, and particularly crimes against for the motive of financial fraud, specifically data related frauds or other financial frauds have risen to a great extent. And recently I was just every second day there are lots of queries coming on financial frauds itself that we handle, and a lot of times they're the lottery scams, some are the job scams, and some are even like I would say purchase of these gadgets. So there will be a fake site where there's a promotional discounted rate, and they will all be fake. So if you recall, in relating to intermediary liability only, there was this case against GoDaddy recently. If you recall, I think Snapdeal versus GoDaddy. So here also they were examining whether the whether the registrars of these websites are liable or not, and whether they are intermediary or not. So that aspect was examined. And when you register a particular domain, it is the user, the subscriber's due diligence that he needs to see if he is infringing anybody's website, because otherwise the platform cannot be made liable for the same. That is what was held in this case in terms of intermediary liability. And interestingly, these cases are coming, and the banks, as I said, banking ombudsman scheme is in order, and there are awareness campaigns being launched by the banks also. They are tightening up the data investigations relating to data, especially financial data, and the awareness is obviously there, the need for training that goes across all stakeholders. But RBI as such is doing a lot. Recently they passed guidelines even for platforms which are selling I would say advertising loan dispersals. So there were so many suicides in the country being reported in the press and media that people are becoming harassed for no reason by these fictitious scam apps, and there is no due diligence which is being done. So there has to be a strict KYC norm, and that is what has recently been passed by the RBI. So as and when these new issues come, we grapple with these issues, make new laws and new rules come into play. So KYCs have to be made stronger. Definitely, I agree on that.
You want to? Please. No? Yeah, just. Thank you very much, Karnika. So nice of you.
Thank you.
Intermediary is very nicely explained. Initially, even myself was what exactly the 2022 rules are, and 21 WRTI Act and 79 IT Act. Nicely explained. Thank you very much. And one more thing of the beauty of the Karnika is she's always in 11th hour rescue of our Friday group and myself also. Suddenly I jumped and she rescued and she joined. Because other speaker some trouble and other thing, even though long back it was arranged. He said then I requested her. Even earlier times also, even midnight also sometime. Without any this thing, I just simply give me 15-20 minutes. Just thank you very much. Karnika.
My pleasure, sir. It's always a pleasure to be here, and it's a privilege to be part of our Friday group fraternity. And I heartily support this initiative because it gives us a platform to understand and learn from each other. And it's again, I would say I'm grateful for this interaction. And I hope you enjoyed learning and sharing this knowledge with me.
Yeah,
Thank
we'll
you.
take your autograph and then your message also, Karnika. It is your autograph, the next page.